Good evening, friends. When we had posted on the YouTube and social media, I received a lot of messages that the king of knowledge is back with his sessions. And today's session is Appeals from Original Decree by Mr. S.R. Somasekhara, a retired Principal District Judge, Bengaluru, Rural District, Karnataka. And we are always so happy that whenever he accepts a request to share his knowledge. And we know that whenever he shares his knowledge, he takes us into the wide spectrum of knowledge. And thank you, sir, for accepting our knowledge, accepting our invite. Over to you.
Good evening, Mr. Vikas Chatrat and all the participants. The title to the subject is Appeals from Original Decrees. Obviously, decrees passed by the trial courts. The reason why I have not chosen second appeal is I did not practice as a lawyer in the High Court, nor I was in the registry of the High Court as a registrar or anything, nor as a judge of the High Court. So therefore, I don't want to venture into a field in which I have no practical experience. Appeals from original decrees, there is no difficulty for me to speak about it. Well, a few basics. Well, about this I have spoken on 1 or 2 occasions. First, we should know what a decree is to know whether an appeal lies against it. Where do we get it? Section 2, subsection 2, CPC. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. Therefore, it is an expression of adjudication. It contemplates an adjudication, not a compromise, not a consent. It contemplates an adjudication of the issues arising between the parties, and maybe either preliminary or final. Of course, definition of what a preliminary and a final decree is not required for today's session. So this part of the definition of decree tells what a decree is. There is an inclusive part in it. It shall be deemed to include the rejection of a plaint. Order 7, Rule 11 specifies the grounds on which a plaint can be rejected. If the plaint is rejected for any of those grounds, then it amounts to a decree in view of this definition. Therefore, an appeal lies. Determination of any question within section 144. It speaks of restitution, a decree for possession, eviction, or any other decree is passed, either ex parte or contested. It is reversed in appeal or on a petition filed by the defendant under Order 9, Rule 13 CPC, the ex parte decree is set aside. In the meantime, the plaintiff executes the decree, takes possession or recovers money or whatever it is. When the decree is set aside, either by the same court in a proceeding under Order 9, Rule 30, or by the appellate court, the defendant is entitled to be restituted. That is, he is entitled to be put into the position in which before the decree came to be passed. So if any order is passed on an application under section 144 CPC, section 2.2 says it is also a decree, therefore an appeal lies. Then Order 21, Rule 58, Sub-Rule 4. When a property is attached in execution of a decree for money, some person who claims the property so attached is his may raise a claim, or on the ground that the property is not liable to attachment at all, an objection may be raised. If the court entertains those claim petitions or objections, it needs to adjudicate in the manner provided in Rule 2, Sub-Rule 2. Order that is required to be passed is under Sub-Rule 3. I am not reading them. There is not necessary. What is necessary for today's presentation is Sub-Rule 4 of Rule 58. Where any claim or objection has been adjudicated upon under this rule, the order made thereon shall have the same force and be subject to the same conditions as to the appeal otherwise, as if it were a decree. So therefore, an order passed after adjudicating a claim or objection in accordance with Order 21, Rule 58 also amounts to a decree and an appeal lies. Then Order 21, Rule 103 CPC. 21 Rule 97 enables a decree holder for possession or a person who has purchased a property in execution, when a decree for money is executed, if the auction purchaser or the decree holder for possession is resisted or obstructed in taking possession, he can maintain an application under Rule 97. If any person other than the judgment debtor is dispossessed, then the person so dispossessed can maintain an application under Rule 99. So these applications under Rule 97 and Rule 99 will have to be decided as though a suit is decided, that is provided by Rule 101. What is the effect of the decision? That is contained in Rule 103. Where any application has been adjudicated under Rule 98 or Rule 100, the order made thereon shall have the same force and be subject to the same conditions as to an appeal otherwise, as if it were a decree. So therefore, an appeal lies against an order passed in a proceeding under Rule 97 or Rule 99. Now, whether it is an appeal under the Civil Procedure Code or under the Criminal Procedure Code or under any civil law, Land Revenue Act or a host of such enactments, or under any criminal law, Forest Act, Excise Act or whatever it is, unless the statute provides for an appeal, it does not lie. There is nothing like entertaining an appeal in the interest of justice under 151 CPC or anything. There must be a specific provision. It's a statutory right. This has been, there is no need for any authority, but that's the legal position. This is very clear from a judgment of the Supreme Court in Superintending Engineer versus B. Subba Reddy. Superintending Engineer versus B. Subba Reddy, 1999, 4 SCC 423. 1999, 4 SCC 423. In para 23, the legal position is summed up. Sub-para 1, para 23.1 is presently relevant. It just says, appeal is a substantive right. It's a creation of the statute. Right to appeal does not exist unless it is specifically conferred. In fact, Section 372 CRPC, corresponding provision in BNSS, I can't just quote it from my memory. It makes it very clear. An appeal shall lie only in the manner, only against orders provided herein. Therefore, it is a statutory right, it is a statutory remedy, unless the statute provides for it. Question of entertaining an appeal does not arise. I will have an occasion today itself to refer to the Superintending Engineer versus B. Subba Reddy in a different context when I take up cross objections under Order 41, Rule 22. For the present, that is sufficient. Now, as most of you know, the provisions of the Civil Procedure Code are contained both in the section portion and in the order portion. All sections do not have a corresponding order. All orders do not have a corresponding section, but some of them have. Now, the sections corresponding to the first appeals are to be found from section 96 to 99 and 105 subsection 2 has something to do with it. Though we find 105 under the subtitle Appeal from Orders, 105 subsection 2 will have some bearing when an appeal is prepared from an original decree. I'll refer to it later. So statutory provisions in the section portion are section 96 to 99 and 105 subsection 2. Order portion, as all of you know, order 41. Here itself, for the novice, something needs to be clarified. There is also what is known as appeals from orders. That is against certain orders, an appeal lies. But that is not an appeal from a decree. Appeals from decrees, original decrees. Certain interim orders. Those are contained in section 104. Against which orders an appeal lies, it is stated in section 104. The corresponding order portion is order 43. To my knowledge, in most of the high courts, they are registered, in most of the states, they are registered as miscellaneous appeals in the district courts and as miscellaneous first appeals in the high court. Today, that is not my concern. I am leaving it there. Now, first, let us take up section 96. Appeals from original decree. Appeal from original decree. Save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. So it is very clear, an appeal lies against a decree, not against a judgment. Though the practice has been for the appellate courts to write in their judgment the first sentence, this is an appeal against the judgment and decree passed by so and so. Technically, it is an appeal against a decree. To which court? To the court authorized to hear appeals from the decisions of such court. The Civil Procedure Code does not say to which court appeal lies from an original decree. It is the local civil courts acts which tell us. In Karnataka, we have the Karnataka Civil Courts Act against a decree passed by the civil judge. A first appeal lies to the senior civil judge. Second appeal lies to the Honorable High Court. Similarly, if the senior civil judge exercises original jurisdiction and passes a decree, depending upon the value of the subject matter of the suit, the first appeal lies either to the district judge or to the High Court. Of course, the Karnataka Civil Courts Act is also proposed to be amended. The bill is passed by both the houses. The governor is yet to give assent to it. So CPC does not tell us. So it is only the local civil courts acts which tell us to which court the appeal lies. Subsection 2. An appeal may lie from an original decree passed ex parte. This is very important because normally when there is an ex parte decree, the defendant chooses to avail the remedy available under Order 9, Rule 13 CPC. But an appeal lies from an ex parte decree also, as is clear from subsection 2. Here, we need to write Order 9, Rule 13 also. In particular, why in particular? Oh yes, only the explanation to Order 9, Rule 13 CPC. Where there has been an appeal against a decree passed ex parte under this rule. So there is an ex parte decree. Defendant has chosen to file an appeal under section 96 CPC. And the appeal has been dismissed on any ground other than the ground that the appellant has withdrawn the appeal. So if the appeal is dismissed on the ground that there was delay in filing it, appeal has been dismissed on merits, has been dispersed other than the ground that the appellant has withdrawn the appeal, or the appeal is dismissed for non-prosecution, then he can't maintain a petition under Order 9, Rule 13. Only when the appellant has withdrawn the appeal, no application shall lie under this rule for setting aside that ex parte decree. So therefore, though both remedies are available, both of them cannot be availed at the same time. In this regard, we may refer to 2005 1 SCC 436, 2005 1 SCC 436. Sham Sundar Sharma. Sham Sundar Sharma versus Pannalal Jaiswal. Pannalal Jaiswal. The scope of Order 9, Rule 30 and Order 41 has been highlighted. Now, for practitioners, it is of some consequence. If the defendant chooses to avail the remedy provided under Order 9, Rule 30, only two grounds are available. He should satisfy the court which has passed the ex parte decree that there is no due service of summons. The other ground available is, though there is due service of summons, he had sufficient cause for not appearing before the court when the matter was called on for hearing. If he fails to bear out any of these two grounds, he cannot succeed in a petition under Order 9, Rule 13 CPC. It's a different matter that the courts take a liberal view in a proceeding under Order 9, Rule 13, only to enable the defendant to have a judgment on merits. That's a different aspect. But the contours of Order 9, Rule 13 are very limited only for this. But if it is an appeal under Section 96, defendant can point out that even though he remained ex parte and there was no contest, the trial court could not have declared the suit at all. Plaintiff had not made out a case. So practitioners and judicial officers would have known, even when the defendant has remained ex parte, or even when he has not filed a written statement, a decree is not automatic. Plaintiff is called upon to prove his claim, and only because if the suit is barred by time, if the defendant has remained ex parte, is no ground. Suit is not otherwise maintainable. Court has no jurisdiction. There will be several other things. Therefore, suit may be dismissed also. So, when the remedy is available under Section 96, so defendant has to convince the court that the trial court could not have declared the suit merely because the defendant did not make a contest. Then, let us go to 96, subsection 3. No appeal shall lie from a decree passed by the court with the consent of parties. I think about 2 months back, I spoke about modes of challenging a decree. I have spoken about this elaborately. There is no appeal from a consent decree. And of course, as I said on the last occasion, I had some view that a consent decree is not the same thing as a decree by compromise. Anyway, the Honorable Supreme Court has said that a consent decree is also a compromise decree. So therefore, there cannot be an appeal against a compromise decree or a consent decree. Subsection 4. No appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by the courts of small causes when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. So this is a restriction on filing an appeal against a judgment passed by a court of small causes. In fact, in the Karnataka Small Cause Courts Act, a provision is made by way of a revision to challenge a decree passed by the Small Causes Court. 97. Where any party aggrieved by a preliminary decree passed after the commencement of this code does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. What does it mean? An appeal lies against a preliminary decree, an appeal lies against a final decree also. But a party who has suffered a preliminary decree does not choose to challenge it by way of an appeal. He allows it to rest. When the final decree is passed and he chooses to prefer an appeal against the final decree, he cannot contend that the preliminary decree is wrong, it could not have been passed. Now, a preliminary decree is passed in partition suits, suits for dissolution of partnership, mean profits, everything. Therefore, a possession followed by mean profits, everything. In all those cases, If the defendant does not choose to challenge the preliminary decree, after the final decree is passed, he cannot say that the preliminary decree also could not have been passed. 98, we will leave it. It is more for the High Court. 99. This is very important. No decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of any misjoinder or non-joinder of parties or causes of action or any error, defect, or irregularity in any proceeding in the suit, not affecting the merits of the case or the jurisdiction of the court. So there cannot be a remand merely for the sake of asking, or merely the court thinks that the matter could be remanded. I will tell in great detail as to when remand is permissible. Merely because there is a misjoinder of parties or non-joinder of parties or misjoinder of causes of action, the trial court's decree cannot be reversed. Or there is some defect or error or irregularity in the proceeding, that is not a ground. But it can be reversed if the merits of the case are also affected. Obviously, such an appeal would lie. The next part is a little confusing. Not affecting the merits of the case or the jurisdiction of the court. This is a little troublesome. If the trial court did not have jurisdiction, a plain reading of section 99 would definitely persuade one to think that the appellate court can reverse that decree. But we'll have to read the provisions of section 99 CPC along with section 21. I had on some earlier occasions referred to these things, but it is worth repeating. Section 21, subsection 1. No objection as to the place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity in all cases where issues are settled, at or before such settlement, and unless there has been a consequent failure of justice. Therefore, an objection regarding territorial jurisdiction will have to be taken by the defendant at the earliest. If that is not taken at the earliest, in the appellate court, he cannot contend that the trial court did not have jurisdiction. The exception is there has been a consequent failure of justice. It's a very exceptional situation unless the party is able to establish that for want of territorial jurisdiction, though the court did not have territorial jurisdiction, it still entertained the suit, and as a result there is a failure of justice, then only the appellate court can reverse the decree. It's a very, very rare situation. Subsection 2, similarly worded, it speaks of pecuniary jurisdiction. No objection as to the competence of a court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity and in all cases where issues are settled at or before such settlement and unless there has been a consequent failure of justice. Therefore, the appellate court cannot reverse the decree of the trial court only on the ground that the trial court did not have pecuniary jurisdiction. Defendant should have raised that plea at the earliest, or there should have been a failure of justice, which is very difficult to demonstrate. Therefore, section 99 CPC, when it says that the appellate court can reverse the decree of the trial court if it is a question of jurisdiction, it means not pecuniary or territorial jurisdiction. It is jurisdiction over the subject matter of the suit. If not more than one, at least on one occasion, I have spoken on this platform, rather made a reference to these three jurisdictions territorial, pecuniary, and jurisdiction over the subject matter of the suit. Lack of territorial or pecuniary jurisdiction does not render the judgment void. It is lack of jurisdiction of the subject matter, which we also call as inherent jurisdiction, not inherent powers under 151. It renders the judgment void. I have used this expression umpteen times. Such a decree is quorum non judice. It is as though a non-judge has passed that judgment, or a judgment given in the absence of a judge. Quorum non judice. It's a decree passed without jurisdiction. So therefore, it is a void decree. Well, I have said it on a number of occasions. A void decree can be ignored. A void decree can be challenged by way of a suit. A void decree can be challenged by way of an appeal. A void decree can be attacked in execution proceedings. There can also be a collateral proceeding. Well, I have spoken a number of times about this, and have also referred to two important decisions in this regard. AR 1954 Supreme Court 340. AR 1954 Supreme Court 340. Kiran Singh versus Chaman Pasha. Kiran Singh versus Chaman Pasha. There are good number of decisions subsequent to it. There is no need for me to refer to each one of them. Suffice if I refer to the latest one, 2019, 3 SCC 594. 2019, 3 SCC 594. Sneha Lata Goyal versus Pushpalata. So if we read these two judgments, it would be very clear to us. Objections regarding territorial or pecuniary jurisdiction have been considered by the courts as mere technicalities. If the objection is as to the subject matter of the suit, jurisdiction is with regard to the subject matter of the suit, then it goes to the root of the matter. Appellate court can interfere. As I said, that void decree can be ignored. A separate suit can lie. It can be challenged during execution proceedings. There can be a collateral attached to it. Last time, I also drew your attention to Section 44 of the Indian Evidence Act 1872, maybe some 42 or something, in Bharatiya Sashtra Adhiniyama, some two sections either way, you will get that there. Verbatim, same thing. So, in the normal course, a decree passed cannot be challenged because it would amount to res judicata and a subsequent proceeding. 40 of the Evidence Act, Indian Evidence Act speaks about it. 44 is an exception to that. This is one important thing. Now, this Kiran Singh requires some explanation. In that case, an argument was advanced that the particular court in a particular state lacked territorial or pecuniary jurisdiction. Supreme Court said, well, if that is the case, certainly it would be a case of quorum non judice. But then, what is the effect of Section 99 CPC and Section 11 of the Court Fees Act of that state corresponding to Section 51 of the Karnataka Court Fees Act? In fact, Section 51 of the Karnataka Court Fees Act, Suits and Valuation, it starts with a non-obstante clause, notwithstanding anything contained in Section 99 CPC. An appellate court shall not reverse the judgment of the trial court only on the ground that there was improper valuation or the court lacked pecuniary jurisdiction. Then, in this Kiran Singh's case, proceeding further, after referring to Section 99, court has said that would be a case of quorum non judice. Otherwise, the judgment stands. Some other some other loophole in the judgment on merits will have to be pointed out. Only on the ground of territorial or pecuniary jurisdiction, the appellant cannot make out a case unless there is a failure of justice, which, as I said at least twice, will be very difficult to demonstrate. Now, I said that 105, though it finds a place under the head appeals from orders, there is something in it, subsection 2, which has a bearing on appeals from decrees also. I'll just read 104 first. An appeal shall lie from the following orders and save as otherwise expressly provided in the body of this court or by any other law for the time being in force, no other orders. A list of orders against which an appeal lies is provided in section 104. 105(1). I stand corrected. I said 105(2). It is 105(1). Let me. There is a reason for me to confuse this subsection because corresponding is order 43 rule 1A2. Therefore, I brought it here. It is not 105(2). It is 105(1). Save as otherwise expressly provided. No appeal shall lie from any order made by a court in the exercise of its original or appellate jurisdiction. But where a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground of objection in the memorandum of appeal. Simultaneously, have a look at order 43, rule 1, capital A, sub rule 2. Order 43, rule 1, capital A, sub rule 2. Sub rule 1 again. Sub rule 1. Order 43, rule A, rule 1A, sub rule 1. Where any order is made under this code against a party and thereupon any judgment is pronounced against such party and a decree is drawn up, such party made an appeal against the decree content that such order should not have been made and the judgment should not have been pronounced. A combined reading of section 105(1) and 43 rule 1A1 would suggest, well, there are certain orders. Certain orders are definitely appealable under section 104 and order 43. In respect of those orders, there cannot be a challenge in the appeal from the decree. It is the decree, when an appeal is filed, which in Karnataka we call as a regular appeal, there cannot be a challenge to that order in the normal. But there are certain orders which are not appealable at all. For example, amendment of pleadings under 6 Rule 17, impleading of parties, Order 1, Rule 10, appointment of commissioner, Order 26, Rule 10, commissioner for local investigation, Rule 9, scientific investigation, Rule 10A. If that application is allowed, or application for amendment is dismissed or allowed, well, that is not an order against which an appeal, statutory appeal lies. There is no compulsion on the part of the aggrieved person to prefer a revision or a writ. He can keep quiet. When he files an appeal against the original decree, if he is aggrieved by that original decree, then he can also contend before the appellate court that the amendment should have been allowed, should not have been allowed. Application for impleadment should have been allowed or should not have been allowed. Commissioner should have been appointed or should not have been appointed for local investigation. The expert opinion should have been taken or should not have been taken under Order 26, Rule 10E. So therefore, the court cannot say, well, you did not challenge it then and there. Neither the opponent can challenge it. So this is sufficient with regard to the section portion. We will now go to the order portion of the Civil Procedure Code, Order 41. I am not reading the whole of it. Certain things I am omitting because they refer to what a memorandum of appeal should contain. There is nothing to interpret there. You will understand it by yourself what an appeal should contain. Memorandum of appeal should contain. Order 41, Rule 1. What a memorandum of appeal should contain. Sub Rule 1, then Sub Rule 2, contents of memorandum of appeal. Sub Rule Order 41, Rule 2. The appellant shall not, except by leave of the court, urge or to be heard in support of any ground of objection not set forth in the memorandum of appeal, but the appellate court in deciding the appeal shall not be confined to the grounds of objection set forth in the memorandum of appeal or taken by leave of the court under this rule. Practitioners know usually when they draft the appeal, they say this appeal is preferred against the decree of such and such a court for grounds listed herein, and for such other grounds to be urged to the leave of the court at the time of hearing. Experience has also shown that the arguments are not confined to the grounds urged, and many times either the grounds are too exhaustive, the whole narration of the facts, or sometimes they are usual thing. Appreciation of evidence is capricious, perverse, everything is there. And some other grounds are urged, doesn't matter. Anyway, when the lawyer says something which is not stated in the memorandum of appeal, and if the judge or the opponent does not say it is not set forth, then impliedly it means that the court has granted leave. But there is something there, proviso, provided that the court shall not rest its decision on any other ground unless the party who may be affected thereby has had a sufficient opportunity of contesting the case on that ground. So the court on its own cannot find out some ground. If it finds that the decree of the trial court is liable to be set aside for some reason not set out in the memorandum of appeal or not urged at the time of arguments, and if it comes to the mind of the appellate court, it should put it across the bar and ask what you have got to say about this. Maybe a question of limitation, which was not raised in the trial court. Trial court has also not addressed to it. It is not set forth as a ground in the memorandum of appeal. The appellate lawyer does not argue it, but it comes to your mind, judge's mind. Then he has to tell, well, is the suit in time? Something of that kind. Then rejection, I don't propose to read it. Rule 3 is important, application for condonation of delay. So there's a provision in the CPC itself for condoning the delay in filing an appeal. So no need to resort to Section 5 of the Limitation Act. Where an appeal is presented after the expiry of the period of limitation specified therefore, it shall be accompanied by an application. So what is that period of limitation? It is available in the Limitation Act. Supported by an affidavit setting forth the facts on which the appellant relies to satisfy the court that he had sufficient cause for not preferring the appeal within such period. Something like Section 5 of the Limitation Act. Of course, courts have taken a liberal view in this matter, only to see that the parties get their decision on merits. I have no problem with that. Subrule 2. If the court sees no reason to reject the application without the issue of a notice to the respondent, notice thereof shall be issued to the respondent, and the matter shall be finally decided by the court before it proceeds to deal with the appeal under Rule 11 or Rule 13 as the case may be. I'll just make a passing reference to Rule 11 later. Subrule 3 is important, both for the practitioners and for judges. Where an application has been made under Subrule 1, the court shall not make an order for the stay of execution of the decree against which the appeal is proposed to be filed, so long as the court does not, after hearing under Rule 11, decide to hear the appeal. Rule 11 contemplates the stage of admission. So if that is not the situation, when the court decides to take up the matter on merits, without passing an order on the application for condonation of delay, there is no question of passing an order of stay. This is something which the judicial officers on the appellate side, lawyers practicing the appellate side should know it. If there is a delay, well, you will have to satisfy the court. Delay also cannot be condoned without issuing notice to the respondent. It is only thereafter, if a case is made out for stay of execution, that can be done. There is no question of condoning the delay ex parte, neither the question of granting stay of execution before considering the application for condonation of delay. For Rule 4, I am keeping it pending. I will take it up along with Rule 33. What has Rule 4 to do with Rule 33? You will know it in another 33 minutes. We'll take it up later. Let us not mix it here. Rule 5, stay. Well, Subrule 1 provides for, this is important, all right. An appeal shall not operate as a stay of proceedings under a decree or order appealed from, except so far as the appellate court may order, nor shall execution of a decree be stayed by reason only of an appeal having been preferred from the decree, But the appellate court may for sufficient cause order stay of execution of such decree. So lawyers appearing for the judgment debtors in execution proceedings, judicial officers dealing with execution proceedings should know. Well, it's a very familiar thing. I have preferred an appeal. Appeal is pending. Execution petition is not maintainable. No. Filing of an appeal does not operate as stay of execution of the decree unless the appellate court stays the execution. Now, this has some bearing on the aspect of limitation also, because the Limitation Act provides for a period of limitation for filing an execution petition. It is usually 12 years from the date of decree, or if the decree specifies the time for performance, 12 years from the date. For executing a decree for permanent injunction, no limitation. For a decree for mandatory injunction, it is 3 years from the date of the decree, or 3 years provided in the decree for the defendant to comply with it. Now, in view of Order 41, Rule 5, if the appellate court does not stay the execution of the decree for whatever reasons it be, the plaintiff decree holder cannot contend that period will have to be excluded while calculating the period of limitation for execution proceedings. He takes that risk. Because when there is no stay order passed by the appellate court for executing the decree, nothing prevented the plaintiff from executing the decree. He cannot say that the period during which the appeal was pending will have to be excluded. There must be a specific order of stay. Therefore, in Karnataka, the courts are reopening after summer vacation tomorrow. Elsewhere, I do not know the situation. So no argument saying appeal is pending, therefore execution petition is not maintainable. No judge will write appeal is pending, execution petition is not maintainable, await orders and all that. No. Ask the lawyer whether there is a stay order. Otherwise, no question of staying execution of the decree, because and the decree holder also runs the risk. This is another important thing. There is one more thing to be stated here. Experience has shown, and experience of judges who are on the verge of promotion will also show at a future point of time. Even when the suit is dismissed, applications are filed under Order 41, Rule 5. Order 41, Rule 5 contemplates stay of execution of a decree. When the suit is dismissed, there is no decree to be executed at all. Therefore, please do not file applications for stay of execution or simply say stay of operation and all that. There is no decree to be operated. There is no decree to be executed. Well, a bit of suggestion to the lawyers. Supposing you want an order of temporary injunction or something in the appellate court, make an application under 39 Rule 192. Of course, if you had the benefit of the order of temporary injunction during the pendency of the suit, the appellate court may take it into consideration or may not take it. It all depends upon the facts of the case. But there is no question of staying execution of a decree which is not existing at all under Order 41, Rule 5. So this is available only to a defendant when there is an appeal. A question of the plaintiff making an application under Order 41, Rule 5 does not arise unless a counterclaim was set up by the defendant and the counterclaim is decreed by the trial court. Then explanation says, well, if an affidavit is filed and all that, that should be sufficient. Sub-rule 2 says the trial court can also pass a decree, and what can also pass an order of stay of execution of the decree. What conditions can be imposed while granting stay by the appellate court and by the trial court are specified in great detail in sub-rule 3 of Order 41, Rule 5 and sub-rule 6. I am avoiding it. Then Rule 9, only procedural aspect, registration. 41, Rule 11, I will just take it. The appellate court, after fixing a day for hearing the appellant or his pleader and hearing him accordingly, if he appears on that day, may dismiss the appeal. The impression appears to be that these powers of Order 41, Rule 11 can be exercised only by the High Court. Even the district courts and the courts of the senior civil judge can. It's a different matter that it is not being exercised, because courts have also taken the view that the appellate court should be too slow in dismissing an appeal under Order 41, Rule 11, sometimes it is necessary to take up the appeal on merits. But there is a provision for dismissing the appeal even without issuing notice to the respondent after hearing the appellant under Order 41, Rule 11. If Subrule 2, if on the day fixed or any other date, so Order 41, Rule 11 contemplates dismissal of the appeal without issue of notice after hearing the appellant or his pleader. Subrule 2, if on the day fixed or any other date to which the hearing may be adjourned, the appellant does not appear. Though the practice is the moment an appeal is filed, if there is no application for any interim order, we issue notice to the respondent. But strictly speaking, we'll have to post the case for hearing under Order 41, Rule 11. If we find that there is no ground at all after hearing the appellant or his pleader, we can dismiss the appeal under Rule 1, Subrule 1. Supposing when we fix the hearing for admission, the appellant does not turn up, it has to be dismissed for non-prosecution. That is Subrule 2. Subrule 3. The dismissal of an appeal under this rule shall be notified to the court from whose decree the appeal is preferred. So if it is dismissed at the stage of admission under Subrule 1, or if it is dismissed for non-prosecution, the result will have to be communicated to the trial court. Subrule 4. Where an appellate court not being the High Court dismisses an appeal under Subrule 1, that is the senior civil judge and the district judge, it shall deliver a judgment, recording in brief its grounds for doing so, and a decree shall be drawn up in accordance with the judgment. So even when the appeal is dismissed under 41 Rule 11 Subrule 1, a judgment has to be written by the senior civil judge or by the district judge. Of course, though the rule does not compel the High Court to give reasons, well, even when appeals are dismissed at the admission stage, elaborate reasons are given. And a decree also will be drawn. Rule 11, time within which it has to be. Rule 12 says date has to be fixed. Rule 14, service of notice, etc. Rule 16, on the day fixed or on any other day to which the hearing may be adjourned, the appellant shall be heard in support of the appeal. The court shall then, if it does not dismiss the appeal at once, that is, hear the respondent against the appeal, and in such case, the appellant shall be entitled to reply. So, Order 41 Rule 11(1) also appellant is heard, that is at the stage of admission. But even after that stage is over, when we take up the appeal on merits, there if the appellant appears and he is heard, if the court thinks there is no need to hear the respondent, it can do so. Rule 17 is equally important. Where on the day fixed or on any other day to which the hearing may be adjourned, the appellant does not appear when the appeal is called on for hearing, the court may make an order that the appeal be dismissed. Something like Order 9, Rule 8 and Rule 9. When the plaintiff does not turn up, the suit may be dismissed. Explanation is important. Nothing in the sub-rule shall be construed as empowering the court to dismiss the appeal on merits. This is important. Now, Order 41, Rule 17, Sub-Rule 1 empowers the appellate court to dismiss the appeal for non-prosecution. But it cannot itself peruse the records and pass a judgment on merits to dismissing the appeal. Nothing in this Sub-Rule 1 shall be construed as empowering the court to dismiss the appeal on merits. So the option to the appellate court is either to adjourn the matter if it thinks that an adjournment is reasonable and it is necessary, or dismiss it for non-prosecution if it finds that sufficient opportunities are given and the appellant or the counsel does not turn up. But it will not enable the appellate court to decide the appeal on merits. The reverse is the position as far as criminal appeals are concerned. The case law at the criminal appeals is criminal appeals cannot be dismissed for non-prosecution. The appellate court will have to peruse the records. Of course, if it is an appeal by an accused in custody, every effort should be made to see that sufficient legal aid is given to him. Some amicus curiae may be appointed or a counsel from the legal services authorities panel is given, that's the law. But anyway, a criminal appeal cannot be dismissed for non-prosecution. Court has to write a judgment. But the situation in the civil appeal is it cannot pass a judgment on merit without hearing the appeal. Sub-rule 2. Where the appellant appears and the respondent does not appear, the appeal shall be heard ex parte. Well, I have heard some advocates telling that there is nothing like ex parte in an appeal. The only note should be absent, respondent is absent. Well, the rule itself says where the appellant appears and the respondent does not appear, the appeal shall be heard ex parte. So it is open even in an appellate to the appellate court also to say that the respondent has remained ex parte. Then Rule 19, where an appeal is dismissed under Rule 11, Sub-Rule 2, that is for non-appearance at the stage of admission, or Rule 17, after admission, he does not appear for arguing on merits. The appellant may apply to the court to please understand if it is dismissed under Rule 11(1) at the stage of admission, well, no question of restoration. If it is dismissed under Rule 11(2) for non-appearance at the stage of admission, or under Rule 17 after admission, when the matter is taken up for hearing on appeals, he does not appear. It's a case of dismissal for non-prosecution. That appeal may be restored. And where it is proved that he was prevented by any sufficient cause from appearing when the appeal was called on for hearing, or from depositing the sum so required, the court shall readmit the appeal on such terms as to cause or otherwise as it thinks fit. It is almost similar to Order 9, Rule 9. Similarity in the language of Order 9, Rule 9 shall not persuade a lawyer to mention as Order 9, Rule 9 for restoration of an appeal. It should be Order 41, Rule 19 is the correct provision, not Order 9, Rule 9. That is applicable to suits. Rule 20, I will come a bit later. It has something to do with Rule 4 and all that. Rule 21. Where an appeal is heard ex parte and judgment is pronounced against the respondent, we have seen under 41 Rule 17 Sub-Rule 2, it can be heard ex parte. Where an appeal is heard ex parte and judgment is pronounced against the respondent, he may apply to the appellate court to rehear the appeal. And if he satisfies the court that the notice was not duly served, or that he was prevented by sufficient cause from appearing when the appeal was called on for hearing, the court shall rehear the appeal on such terms as to cause or otherwise as it thinks fit to impose upon him. So you will find that Rule 19 is similar to Order 9, Rule 9. Rule 21 is similar to Order 9, Rule 13. Then, Rule 20, where it appears to the court at the hearing that any person who was a party to the suit in the court from whose decree the appeal is preferred. Let us take a suit for specific performance, where prior to the filing of the suit and subsequent to the agreement of sale in favor of the plaintiff, the person who has entered into the agreement of sale sells the property to a third person. He is also made a party to the suit, usually the second defendant. Or in a partition suit, there will be a number of defendants. Or in any other suit for declaration of title or whatever it is, but who has not been made a party to the appeal, he is instituted, he is interested in the result of the appeal, the court may adjourn the hearing to a future date to be fixed by the court and direct that such person be made a respondent. You see, under Order 1, Rule 10, Sub-Rule 2, it is not just the prerogative of the plaintiff to implead a person as an additional defendant, nor the prerogative of a person to get himself impleaded. The court can also suo moto implead a person. Here also under Rule 20, if the appellate court finds that some person who has made a party to the suit is not made a party here, and his interest is likely to be affected by a judgment in the appeal, the appellate court can direct the appellant to make him a respondent. Well, this has again something to do with Order 41, Rule 4 and Rule 33. I will refer to them later. No respondent shall be added under this rule after the expiry of the period of limitation for appeal, unless the court, for reasons to be retarded, allows that to be done on such terms as to cost as it thinks fit. Now, before I take up Rule 22, cross objections, which requires some elaboration, let me refer to the provisions regarding remand, scope of Rule 24, Rule 25, Rule 26 has a bearing on Rule 25, additional evidence under Rule 27 and allied provisions 28 and 29. I request the lawyers to give full attention to what I am telling. I request the judicial officers who may be already exercising powers of the appellate court or who are about to exercise it in a few months' time to give me a patient hearing to this. This is one area where we have presumed much. An appellant lawyer thinks that seeking a remand is a matter of right. An appellate judge thinks that he has ample powers to remand a matter. Well, any power will have to be exercised strictly in accordance with the statute. Any right or remedy will have to be exercised or utilized in accordance with the statute. We can't rewrite a statute, be a lawyer or be a judge. Let us see the contours of these powers of remand. Rule 23. Where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point, usually we call it as a preliminary issue, and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case. The reason is obvious. This usually happens when a suit is dismissed on a preliminary issue. Order 14 provides for framing of preliminary to trying certain issues as preliminary issues. On a preliminary issue, the suit is dismissed. Therefore, the trial court did not try the other issues or did not give a finding on other issues. The appellate court reverses the finding of the trial court on that preliminary issue. It might hold, well, certainly the trial court had jurisdiction. Suit was perfectly maintainable. Since there was no evidence regarding the other issues on merits, or there was no finding of the trial court, the appellate court on its own cannot give a finding on the merits of the case without evidence, or even if there is evidence and the trial court has not given its findings, the appellate court cannot do it. It is only in such situations remand is contemplated under Rule 23. Here afterwards, judicial officers, when they are remanding the matter, they will specify in their order whether they are remanding under Rule 23 or Rule 23A. It should be very clear. Lawyers also, when they seek a remand, are they seeking remand under Rule 23 or Rule 23A? You see, unless we set our house in order, be it judges or lawyers, we can't point out fingers at others. You see, we should read it. We should know our powers. We should know our limitations. We should know what the statute has provided. We can't presume something, some quote, some saying, in some situation, for some reason, matter is remanded. There have been situations where even a decision of some additional judge is cited before the principal judge. The decision cited by the principal, given by the principal judge, saying that the adjacent court has given this, the other court has given this. Let us give up all these practices. Let us see what the Supreme Court has said, as what the High Court has said, or what the statute provides. See, there is nothing to interpret these things. The provisions are very, very clear. See, we are making an incorrect beginning. We start from the commentaries and decisions. Let us first read the statutes, understand them. So, Rule 23 makes it very clear. Only when the appellate court reverses the judgment of the trial court or a preliminary point, it can remand and direct. Rule 23A, where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal, and a retrial is considered necessary. Retrial, please mark those words. The appellate court shall have the same powers as it has under Rule 23. Well, this remand for retrial under Rule 23A is an extreme situation. I will give one or two examples for this. Now, Order 8, Rule 1, when it came to be amended in 1999 and 2002, provided for a period of 30 days for filing the return statement from the date of service of summons. That period can be statutorily extended by another 60 days. Supreme Court in a good number of judgments has said, well, it is not a mandatory rule, the provision is only directory. For some good reasons, even beyond 90 days, the return statement could be received. Of course, subject to payment of costs. Now, let us take a case where defendant did make an application for taking the return statement on record beyond 90 days. The trial court did not find good reasons to entertain that application and dismissed the application and declared the suit on the ground that there was no return statement, there was no contest and all that. Defendant is in appeal. The appellate court finds that there were really valid grounds for the defendant for not preferring the appeal within that 90 days. I have already pointed out under section 104(1) and order 43, any irregularity in the proceeding, any other order can also be challenged there. Well, if the appellate court thinks, well, certainly sufficient grounds had been made out by the defendant for not filing the return statement in time. There is no written statement. That written statement cannot be received in the appellate court, issues cannot be framed, evidence cannot be recorded there. This will be an extreme case where retrial is necessary. Well, it all depends upon the situations. I'm only just giving one such example where a retrial is required. Or maybe there is a substantial amendment to the plaint or a substantial amendment to the written statement. Opportunity was not given to the other side to meet that amended pleading. Trial has proceeded. These are very rare situations where a remand is permitted under Rule 23A. I am only impressing upon the audience comprising the judicial officers and lawyers. Remand is not a matter of right or it is not a matter of power. I am only reminding you of the powers of remand. Remand is statutorily provided under Rule 23, Rule 23A. So if an appellate judge remands the matter, his judgment should be very clear. He is remanding it under Rule 23 or Rule 23A. If a lawyer seeks a remand, he should say he is seeking remand under Rule 23 or Rule 23A. Otherwise, we presume certain things, go by something which has happened. This will go on. Let us put an end to this. It's a learning process. Let us make a good learning. Then Rule 24. Where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resettling the issues if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon such ground other than that on which the appellate court proceeds. Well, we have one basic principle. If a specific issue or a specific plea raised either by the plaintiff or by the defendant is not framed, but if the parties have understood the case of the opponent of each other and they have gone to trial knowing that it was an issue, that would not be a case for remand. Trial court for some reason has not framed a specific issue. Plaintiff knew this is the precise case of the defendant. He chose to meet the case of the defendant by giving some evidence. He chose to cross-examine the defendant and his witnesses at great length on that stand of the defendant. Defendant knew what the case of the plaintiff was. He cross-examined the plaintiff and his witnesses. He let his own evidence on that, though no specific issue was framed. That cannot be a ground for remand. The appellate court itself, in its judgment, may raise an additional point for consideration or an additional issue because evidence on record is already there, where the evidence upon the record is sufficient. Let us take a case. Readiness and willingness in a suit for specific performance has to be established by the plaintiff. There is no doubt about it. Of course, now we know the amendment brought out in 2018. There is no need to hour it, but the requirement of proof is still there. Now, let us say a case prior to this amendment, there was no plea of readiness and willingness. Or there was a plea, but trial court did not frame an issue. Let us say, because we are on the point of issues, let us not go to the pleadings. Trial court, for some reason, did not establish its readiness and willingness to frame an issue regarding readiness and willingness. Lawyers also did not exhibit their readiness and willingness to bring to the notice of the trial court that this issue was required. But they were ready and willing to give evidence about that. So there is ample evidence regarding readiness and willingness. Therefore, it is not a case for remand. The appellate court will raise one point for consideration whether the plaintiff respondent or plaintiff appellant or whoever is has established his readiness and willingness, not a case for remand. Let us take a case of a plea of adverse possession. So defendant has raised a plea of perfection of title by adverse possession. For some reason, the trial court does not frame an issue. Neither lawyer brings to the notice of the trial court that an issue is not framed in that regard. But plaintiff has understood that that is the case of the defendant. He has led evidence to show, defendant could not have been in adverse possession as pleaded by him. Defendant, though there was no issue, has given some evidence regarding adverse possession. Witnesses have been cross-examined. That means both the parties knew that they were at issue, though no specific issue was framed. This is a basic principle. If that is a case, it is not a case for remand, is all that is contained in Rule 24. Rule 25. Where the court from whose decree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon the merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred, and in such case shall direct such evidence to take the additional evidence required. And such court shall proceed to try such issues and shall return the evidence to the appellate court together with its findings thereon, and the reasons therefore within such time as to be fixed by the court or extended by it from time to time. I will read Rule 26 also. Then you will be able to understand the scope of Rule 25. Such evidence and findings, that is, such evidence and findings on that additional issue framed by the appellate court and directed to be tried by the trial court, shall form part of the record in the suit, and either party may, within a time to be fixed by the appellate court, present a memorandum of objection to any finding. The reason is this. The memorandum of appeal that was filed earlier, or the cross-objection that was preferred earlier, was in respect of the issues which had been framed. Now the appellate court itself frames an additional issue, directs the trial court to try that, to record evidence on that issue and give a finding. Therefore, the appellant or the respondent did not have an opportunity to challenge the finding of the trial court on that additional issue. Therefore, Rule 26 contemplates an opportunity, giving an opportunity to the both parties to have their say on the finding of the trial court on that additional issue. Sub-rule 2. After the expiration of the period so fixed for presenting such memorandum, well, the trial court gives its findings on the additional issue, sends it to the appellate court. Some reasonable time has to be given by the court to both the parties to have their say on this finding. After the expiration of that period, the appellate court shall proceed to determine the appeal. Rule 26 of Rule 1 shall form part of the record of the suit at either party. Now, what does this mean? See, Rule 25 also does not contemplate a remand. Please understand this. Under Rule 25, what the appellate court is required to do is, it will itself frame an additional issue. Well, this additional issue is absolutely necessary. It arises from the pleadings. Because there was no issue, the parties did not lead evidence. If they had let in evidence, Rule 24 would apply. Please understand the distinction between Rule 24 and Rule 25. Under Rule 24, if there is evidence on an issue, though not specifically framed, that would not be a case for remand. The appellate court will itself give a finding and dispose of the appeal. Under Rule 25, issue is not framed. Evidence is also lacking. Though Rule 25 does not say so, we will have to read Rule 24 and 25 together. So Rule 25 contemplates a situation where an issue was not framed, there was no evidence, absolutely that issue was necessary. Well, a suit for partition where a prior partition is set up by the defendant. Obviously, an issue is necessary. Because there was no issue, parties did not lead evidence. If they had led evidence even without an issue, not a case for remand, Rule 24 will take care of it. Readiness and willingness. Well, if there is evidence, Rule 24. If there is no evidence, Rule 25 frame that issue. Several things, adverse possession, number of such questions will arise. So Rule 25 does not contemplate disposal of appeal on merits. The appellate court will have to hear the parties in great detail. If it finds that a material issue had not been framed and there is no finding on that issue, there is no evidence regarding that issue, the appellate court will frame that issue, defer the judgment, defer the appellate court's judgment, keep the record on its file, not a case of remand, direct the trial court to record evidence on that additional issue, give a finding, fix a time limit. The appellate court may also say, if the trial court makes a request for extension of time, the appellate court can grant that time. After the trial court gives its finding and sends it to the appellate court, both the parties will have to be given an opportunity to have their say regarding that additional finding and then dispose of the appeal on merits, taking the evidence already on record and the additional evidence on the additional issues. Here, for the judicial officers who are recently promoted or going to be promoted, a word of caution, because I have seen this. See, when the appellate court directs the trial court to record evidence on an additional issue and give finding, all that the trial court is required to say is finding an additional issue framed by the appellate court, finding an additional issue number 1, 2, 3, or whatever it is. It cannot traverse beyond that. It cannot say that the suit is barred by time, suit is bad for non-joinder. It cannot style its order as a judgment. I am speaking with some experience because for lack of correct understanding of the scope of Rule 25, some of the appellate judges, newly promoted and others, well, maybe there is some contribution from the bar also for this misunderstanding of the legal position. Everything would have happened. So whatever it is, we will have to, we can't blame each other. Lawyers should know it, judges also should know it. So Rule 25 does not contemplate writing a judgment by the trial court. All that it is required to give is only a finding. Well, to give a finding on that additional issue, well, it may have to summon some documents, it may have to summon some people, it may have to appoint a commissioner for local investigation, it may have to appoint a handwriting expert, a fingerprint expert. Well, that is why Rule 26 also says, Rule 25 itself says, the appellate court may even extend the time given by it for recording a finding. The appellate court says, all right, 2 months or 3 months time is given to the trial court to record a finding on this additional issue and send it. But sometimes that time may not be sufficient. If it is a case where the trial court thinks that a commissioner has to be appointed for local investigation, some survey is required, encroachment is required to be determined, or the services of fingerprint or handwriting expert or DNA expert is required. All that would take time. Appellate court can liberally grant that time. So Rule 25 does not empower the trial court to write a judgment. It does not empower the trial court to frame some additional issues on its own. No. It does not empower the court to amend the issues. It has to confine itself to the issues framed by the appellate court and give a finding on it. Well, obviously, it might require some evidence in that regard. So, judicial officers will please remember the scope of Rule 25. Because you can't say that the suit is bad for non-jointer of necessary parties, suit is barred by time. All that, well, the lawyers will urge in the appellate court, the appeal is still pending. It is not a case of remand. So you will have to keep the appellate records pending, avoid findings from the trial court. After that, you will rehear the appeal because a good lot of time would have spent. By then, you would have been transferred, your successor would be there. It takes a good lot of time. Then, we will take up this additional evidence also under Rule 27. This is yet another provision which is more misunderstood than understood correctly. Production of additional evidence in the appellate court. Does it contemplate a remand? No. The parties to an appeal, see the language, shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. Well, CPC was amended in 2002-99. Order 7, Rule 14 contemplates filing the documents on which the plaintiff relies upon or sues upon, and copies to be produced. If not produced at that stage, Rule 714 provides for leave to be granted by the. Similarly, for the defendant, Order 8, Rule 1A. Along with the written statement, he has to file it, otherwise leave is to be sought. 13, Rule 2 has been deleted. That is the position in the trial court itself, so many restrictions. It's a different thing that we liberally exercise. We may have to, that's a different situation. But Rule 27 makes it very clear. It is not the right of a party to produce additional evidence in the appellate court. Unfortunately, what is happening is, in every appeal, apart from applications under 41 Rule 5, 39 Rule 1 and 2, 41 Rule 27 is another application. It is not just one application under Order 41 Rule 27. IA number 1 under 41 Rule 27, when the case is posted for hearing on merits, another application, IA 3 under Order 41 Rule 27. And the 41 Rule 27 does not say it is only for the appellant. Respondent does not lag behind in filing similar applications under Order 41 Rule 27. There have been umpteen situations where there are umpteen applications under 41 Rule 27. I am not exaggerating. I have seen this. Therefore, I am speaking about it with some authority. These applications under Rule 27 are very casually filed as though they are applications under Rule 714, Order 7, Rule 14, for the plaintiff to file additional documents, or under Order 8, Rule 1A. Please see the restriction placed by Rule 27. When can an additional evidence be received by the appellate court? The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court, but A, if the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted. Let us take a case where a document is not admitted in evidence by the trial court on the ground that it is insufficiently stamped or not stamped at all. If the appellate court comes to the conclusion that it was sufficiently stamped or sufficient stamp duty and penalty was paid, or it was not a document for which stamp duty was not required at all. It's a case where the trial court should have admitted that evidence, but it has refused to admit that evidence. A case of non-registration of a document. Well, neither the Registration Act nor the TP Act would have contemplated registration of such a document. The trial court thinks that the document required registration, therefore did not admit it in evidence. Well, the appellate court can do so. Or it may be a case where that document could have been admitted in evidence to prove a collateral transaction. I have said on a number of occasions, it is not collateral purpose that is provided in Section 49 of the Registration Act. The expression used is collateral transaction. There are certainly a collateral transaction to prove which that unregistered instrument would have been admitted in evidence. The trial court felt that there was no collateral transaction or for some reason did not admit it. Has refused to admit evidence which ought to have been admitted. There may be a number of other situations. A. So A contemplates failure on the part of the trial court to admit evidence which it should have admitted. A contemplates inability of the party to place evidence before the trial. A, failure on the part of the trial court to admit evidence which it should have done. A contemplates a situation where the inability of the party, either the plaintiff or the defendant, to produce that evidence in the trial court. Please understand, Rule 27 is not confined only to documentary evidence, though in practice, Rule 27 is taken as meant for only giving additional documents. What is that AA? The party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed. Let us take a suit for partition. Suit is dismissed on the ground that all the joint family properties were not included. Well, the plaintiff was a government servant or employed somewhere. He left the village some 30 or 40 years back. He did not know what other properties were acquired by other members of the family from out of joint family funds. He confined the suit only to the properties about the existence of which he knew when he left the village. He did not have any access to documents. Maybe some villager was not properly advised. He did not know any of those things. There he may come across some documents despite exercising due diligence. Now, what I am finding is a case under AA is not made out by clearly telling that this was the evidence which the trial court should have admitted. It has wrongly refused to admit it. No ground is stated. AA, why the appellant or the respondent could not lay his hands on this document? Simply, in the interest of justice, this document is required. No case, whether it is A or AA, is not made out at all. See, we can't expect the appellate court to allow the application under Rule 27 as the trial court does it when an application is filed under Rule 714 or Order 8, Rule 1A. Well, naturally, the trial courts are liberal. I have no problem about it. They should be liberal. But when it comes to an appellate court, what's our experience? 6 years, 7 years would have gone on. Here, even after filing the appeal, number of adjournments are taken. When the matter is listed for final hearing, suddenly an application is filed very casually under Order 41, Rule 27. These are essential documents. My experience has shown normally no request for letting in any oral evidence but as an additional evidence. It is only documentary evidence. What are those documents? In the trial court, either the plaintiff or the defendant would have produced the originals of those documents. Here, this man produces certified copies of them. or he has already produced certified copies, they have been marked, everything is done. Here he produces originals, though they may not be required. Or the revenue records. He would have produced all revenue records. One more set of revenue records are produced here. Revenue records pertaining to a period subsequent to the filing of the suit. It is of no use. Revenue receipts, tax receipts, evidencing payment of land revenue and tax during the pendency of the suit. Parallel proceedings would have gone before the land revenue authorities. They would have passed some orders during the pendency of the suit or during the pendency of the appeal that is produced. And what they normally do is when they come to know that a suit is pending or an appeal is pending, they will say, it is brought to the notice that an appeal is pending in the such and such a court or a suit is pending. Parties are advised to agitate their rights before the civil court. That order is produced. So these are not things which really matter. I may tell you from my experience, even when I have dismissed applications under 41 Rule 27, I have allowed appeals. The evidence on record was sufficient for me to allow the appeal, dismissing the application under 41 Rule 27. There have been a number of instances. So therefore, filing of the appeal under Order 41 Rule, application under 41 Rule 27 cannot be in a very casual manner. The lawyer who drafts an application under 41 Rule 27 will have to say why the trial court did not admit that evidence it should have admitted, a case under Rule A or AA. Despite simply a vague sentence, no, that will not be sufficient. There is B. A, failure of the trial court to admit evidence which it should have. AA, inability of the party to place evidence. B, requirement of the appellate court. The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. Well, this is an extreme situation where the appellate court itself might think, well, this production of this document would have clinchered the issue. The examination of this witness would have done it. So these are the situations which provide for receiving additional evidence in an appellate court. So judges who are dealing with these applications under 41 Rule 27 will carefully and meticulously peruse the application and find out whether a case is made out by the appellant under Rule A or AA, or the appellate court makes out a case under Rule B. Otherwise, there is no question of allowing these applications. Lawyers who draft the applications will have to apply their mind to the provisions of Rule A and AA. Then what happens? The appellate court may allow such evidence or document to be produced or witness to be examined. Whenever additional evidence is allowed to be produced by an appellate court, the court shall record the reason for its admission. Therefore, reasons will have to be given when an application is allowed under Order 41 Rule 27 as to why the appellate court records receives that additional evidence. Rule 28 is equally important. Wherever additional evidence is allowed to be produced, that is under Rule 27, the appellate court may either take such evidence or direct the court from whose decree the appeal is preferred, or any other subordinate court to take such evidence and send it when taken to the appellate court. Does it contemplate a remand? Practice has been when an application is filed under Rule 27, the appellant lawyer says, I have filed this application in Rule 27, the matter may be remanded. Respondent lawyer may say, all right, I have no problem. Judicial officers say, both of them are saying, I'm remanding it, I'm getting a case for disposal. Rule 27 does not contemplate a remand. You shall not remand it. Please make it very clear. Please take this to your heart. I request the judicial officers to take this very seriously. Rule 27 does not contemplate a remand. I am forced to raise my voice at this juncture, which I normally do not do. Because despite telling this, I have been seeing judicial officers remanding the matters when an application is filed under Rule 27. It is highly impermissible. Rule 28 says, the appellate court may itself record evidence or direct the trial court to do it. how the appellate court has to record evidence, how the documents need to be marked, all that when I have addressed appellate court judges in the Judicial Academy, have told them this is not the right forum because practices in different states may be something. Nothing is stated in the Civil Procedure Code. Well, when an occasion comes, I will tell them. So there is no question of remanding the matter under Order 41, Rule 27. Either the appellate court may itself record evidence or the trial court may record evidence. Now let us say some witness is examined on the side of the plaintiff, PW2. He is required to be examined. Through him, some document is required to be got marked. Well, the appellate court may say, PW2 examined in the trial court is recorded by me today in this appellate court in RA so and so. Further examination in chief, cross-examination and all that. Or the appellate court will have to keep the appeal pending. It can't dispose of the matter and remand the matter. Keep the appeal pending and direct the trial court to record evidence. Then points to be defined and recorded. Where additional evidence is directed or allowed to be taken, the appellate court shall specify the points to which the evidence is to be confined and record on its proceedings the points so specified. So if it is not specified, the trial court will record evidence on all matters, will receive additional documents which were not produced before the appellate court. So the better thing is for the appellate judges to record evidence by themselves, because they have already the experience of trial judges, they have heard the appeal, they know it. One more thing which is not stated in the rule, it is the precedent law which says is, these applications for additional evidence under 41 Rule 27 cannot be disposed of independently. They will have to be heard along with the main matter. Because it is only when the main matter is heard, the appellate court will come to a conclusion whether additional evidence is really required, whether a case under A, AA or B is made up. Otherwise, there is no question of considering these applications. As I said, I will repeat it. Experience has shown that at least in 99% of the cases, absolutely no case is made out for recording additional evidence under 41 Rule 27. Lawyers say the matter may be remanded. Judicial officers mechanically remand the matter when additional evidence. I am really at pains to notice this. I feel a little agitated when it comes to Rule 27. Anyway, I see a few good judicial officers who always take things not just to their heads, to their hearts also seriously. I have some hopes on two of them whom I see here. I am sure that when they get promoted, they take it to their heart and see that Rule 27, 28 is implemented in letter and spirit. I request the lawyers not to seek for remand when applications are filed under Rule 27. You please persuade the appellate court judges to themselves record evidence. Because if the matter is sent to the trial court to record evidence, they will have their own problems already. This is with regard to this. Then, let us take up Rule 22. This is something to do with cross objection and something else. Any respondent, I will now tone down. When it comes to Rule 27, Rule 23 and Rule 23, remand, I get a little agitated. I'll be back to my normal mood because absolutely nothing. But I really get disturbed when matters are remanded casually by the first appellate courts when applications are filed under Rule 27. Rule 22. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below, in respect of any issue, ought to have been in his favor, and may also take any cross objection to the decree, which he could have taken by way of appeal, provided he has filed such objection to the appellate court within 1 month from the date of service on him or his pleader, or the notice of the day fixed for hearing the appeal, or within such further time as the appellate court may see fit to allow. So this limitation for filing cross objection is provided in Rule 22 itself. That is, within 1 month from the date on which the respondent receives notice of hearing of the appeal, that the time may also be extended. Rule 3A or Section 5, the limitation it does not apply. It itself provides for it. Now, any respondent, though he may not have appealed from any part of the decree, may not only support the decree. See, the judgment of the trial court is in favor of, let us say, the defendant or the plaintiff. Obviously, when the entire judgment is in his favor, there is no occasion for him to prefer an appeal merely because a finding on a particular issue is against him. Let us take a case where the suit is dismissed on merits. Several contentions are urged by the defendant. Execution of a document is not proved by the plaintiff. Something else is not proved. Defendant has also raised a question of limitation. Trial court says that the suit is in time, but yet dismisses the suit on merits for some other reason. There is only a finding against the defendant. There cannot be an appeal against that. Why should you do it on his own? Now the plaintiff files an appeal challenging the decree of dismissal. Here there is a finding on a particular issue regarding limitation or some other issue against the defendant. He need not prefer an appeal or a cross objection against that. He may say, well, the finding on that issue also should have been in my favor. The finding on all other issues is in my favor. The trial court has wrongly said that the suit is in time. The trial court has wrongly taken this view. That should have also been in my favor without preferring any cross objection. May not only support the decree, but may also state that the finding in the court below in respect of any issue ought to have been in his favor, and may also take any cross objection. This is an amendment brought into Art 41, Rule 22, when CPC was amended in 1976. Because when there is no decree against the defendant, when there is only a finding against him, and when the plaintiff prefers an appeal, there is no question of the defendant preferring an appeal, but he can challenge that finding without preferring a cross appeal or a cross objection. Now under Rule 22, he can also prefer a cross objection against that, but he is not bound to do it. Then there is something more to tell. I will read the explanation also. A respondent aggrieved by a finding of the court on the judgment on which the decree appealed against is based may, under this rule, file cross objection in respect of the decree in so far as it is based on that finding, notwithstanding that by reason of the decision of the court on any other finding which is sufficient for the decision of the suit, the decree is wholly or in part in favor of that respondent. Now the situation boils down to this. Ultimate decision is in favor of the defendant. Suit is dismissed. A finding on a particular issue or a finding on a particular point is against the defendant. Ultimate decision is in favor of the defendant. Defendant cannot prefer an appeal on that finding. But when the plaintiff prefers an appeal against a decree of dismissal, defendant has got these options. He may say, without preferring a cross objection or a cross appeal, he may say, well, that finding should have also been in my favor. Or he may also file a cross objection regarding that finding. That is an improvement brought. But on a mere finding against him, when there is no decree against him, he cannot prefer an appeal. Now, I will just give you a list of decisions and sum up what the legal position in that regard is. One important decision which the lawyers and the judicial officers will take note of is by Justice R.C. Lahoti in this famous Banarsi versus Rampal. Banarsi versus Rampal, reported in 2003, 9 SCC 606. 2003, 9 SCC 606. It deals with the scope of Rule 22, Rule 4 and Rule 33. Rule 4 and Rule 33, I'll take them up together. They are very, very important. All these things you'll have to read together. That's why I kept them at the end. This paras 9 to 11 in this judgment, they deal with Order 22, Order 41, Rule 22. Para 15 deals with Rules 4 and 33. 2003 9 SC606. I'll just sum up the legal position emerging from all these decisions in my own words. The next decision that you will read with regard to this cross objection is 1999 4 SCC 423. 1999 4 SCC 423. Superintending Engineer versus B. Subbareddy. Of course, this decision I already drew your attention while dealing with the question whether there can be an appeal when a statute does not provide for it. In that regard, I have already drawn your attention to this. With regard to Rule 22 also, you may read this decision A. Then, AER 2007 Supreme Court 989. AER 2007 Supreme Court 989. Yes, Nazir Ahmad versus State Bank of Mysore. Yes, Nazir Ahmad versus State Bank of Mysore. Obviously, a decision from the Karnataka High Court. Para 7 deals with Order 41, Rule 22. Para 8 deals with Order 41, Rule 33. Because I'm referring to Rule 33 decisions also here, because most of these decisions cover not only Rule 22 and Rule 33. Then, you will also read 2003 3 SCC 552. 2003 3 SCC 552. Chandramohan Ramachandra Patil. Chandramohan Ramachandra Patil versus Bapu Koyappa Patil. 2003 3 SCC 552. This is with regard to Order 41, Rule 4 and Rule 33. This is paras 12 to 15. Then, AER 2004 Supreme Court 2546. AER 2004 Supreme Court 2546. Bajranglal Shuchandar versus Shashikant. Well, this it is said ranked first in the hit list and referred 11 times. So obviously, an important decision, which you will read it for yourself. Now, first you read this Banarsi Das. There is what is known as a concept: supporting a decree and attacking a decree. Please follow this very carefully. Respondent to support a decree, because the decree of the trial court is in his favor. Respondent may be the plaintiff, respondent may be the defendant. The ultimate decision of the trial court, the ultimate judgment or decree of the trial court is in his favor. He needs to support the decree. If he wants to support the decree, he need not prefer a cross objection. Now, let me make it more simple. A question of limitation was raised by the defendant. Trial court did not accept his contention, held that issue against the defendant, but yet dismissed the suit on other grounds. Plaintiff is in appeal. Respondent defendant raises the question of limitation in the appellate court. The appellate court cannot say you have not preferred any cross objection. Neither the appellant lawyer cannot say that he has not preferred a cross objection. Because 41 Rule 22 enables him to say that the finding on that issue also should have been in his favor. If he still wants to file a cross objection against that finding also, it is permitted. But when there is no decree at all against him, he cannot simply file a cross appeal saying that there is that finding. No. So this cross objection to a defendant, right of cross objection to a defendant could come only when a plaintiff files an appeal. This is one of the aspects. Now, to support a decree, without a cross objection, respondent can contend. This finding should have been in my favor. The trial court has erred in this regard. But to attack a decree, this is important. Here I will give you some examples. Let us take a suit for specific performance. The prayer in the suit is to grant a decree for specific performance, or in the alternative for refund of earnest money, or for compensation under section 21. Though 21 compensation is very rarely sought, refund of earnest money under rule 20, section 22 of the specific effect is usually sought. Now, the defendant has disputed the very execution of the agreement of sale. Please understand this. Suit is for specific performance. There is a prayer for relief of specific performance, alternately for refund of earnest money or compensation. Defendant has specifically disputed the execution of the agreement of sale. Trial court holds that the agreement of sale is proved. It also holds that it is not a case for grant of specific performance, instead grants a decree for the alternative relief of refund of earnest money or compensation or whatever it is. Normally, it is earnest money that is sought and that is given. Please understand here, there is a decree against the defendant to refund earnest money, or there is a decree against the defendant to compensate the plaintiff for breach of the contract. Now, plaintiff prefers an appeal saying, the main relief of specific performance itself should have been given to me. I had made out a case, though by way of abundant caution, I had also prayed for an alternative relief of refund of earnest money or compensation. I had made out an excellent case for grant of specific performance. Therefore, he challenges the decree of the trial court on that ground. Here, the defendant cannot rely upon the main part of Rule 22 and say, well, the finding on the issue regarding the agreement of sale also should have been in my favor, because there is a decree against him for refund of earnest money. He has to attack the decree. Here, filing of a separate appeal, which you may call as cross appeal, or a cross objection in the appeal filed by the plaintiff is absolutely necessary. I repeat, to support a decree, no cross objection is required. But to attack a decree, it is obvious, it is absolutely necessary. Suit is for recovery of money. Plaintiff claims 20 lakhs. Trial court says only a case is made out for 15 lakhs. So there is a direction, there is a decree against the defendant to pay 15 lakhs. A defendant does not prefer an appeal. Let me see, when the plaintiff files an appeal, he simply keeps quiet. Why pay for so much of court fee and 15 lakhs and all that? He keeps quiet. Having seen the plaintiff, he knew that he wants the entire money. So plaintiff files an appeal challenging that part of the decree, refusing to give a decree for the entire claim for the remaining 5 lakhs. Here, the defendant cannot say under 41 Rule 22, I will say that the finding that the entire amount was due is incorrect. No. He has to get over the decree in respect of 5 lakhs by filing a cross appeal or a cross objection. A suit for partition. There are some 4 or 5 items. Some of them are held to be self-acquisitions. Or claimed to be self-acquisitions. The trial court says that only items 1 to 3 are joint family properties, rest are self-acquisitions. So it dismisses the suit in respect of self-acquisitions, grants a decree. Plaintiff prefers an appeal, saying that there should have been a decree in respect of all the properties. Here, there is a decree against the defendant in respect of items 1, 2, 3, which are held to be joint family properties. Here, the defendant cannot say, under 41 Rule 22, I say that the finding in respect of those properties also should have been in my favor. So, to attack a decree, to get over a decree, a cross objection is required. Only to support a decree or attack a finding, cross objection is not required. If the defendant chooses, that can be done. Then, these are some important decisions which you will read. Now go to Rule 4 and then Rule 33. With that, I will end. Rule 4. Where there are more plaintiffs or more defendants than one in a suit, and the decree appealed from proceeds on any ground common to all the plaintiffs or to all the defendants, and any of the plaintiffs or of the defendants may appeal from the whole decree, any one of the plaintiffs or of the defendants may appeal from the whole decree, and thereupon the appellate court may reverse or vary the decree in favor of all the plaintiffs or defendants as the case may be. Well, the best example here is a partition suit. A claim for partition is made, some 2 or 3 plaintiffs or defendants or whatever it is. So a common defense is raised, or the grounds urged in the plaint will be the same. Now there is a decree or dismissal or whatever it is. It is not necessary for all the plaintiffs to prefer an appeal, or not necessary for all the defendants. It says any one of the plaintiffs or the defendants may on behalf of others prefer this appeal. This is provided. Though normally they do it, or if one of them does not wish to join as the appellant, he will be shown as the respondent. That is the practice. Fine practice, there is no problem. If for some reason, well, taking advantage of Rule 4, a lawyer may say, well, he doesn't, I'll fight for him also, that can be done. Well, some Rule 33 has also something to do this, because in this Banarsi Das case, Rule 4, Rule 33 have all been analyzed. Please go to Rule 33. Power of the Court of Appeal. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties. Although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits or where 2 or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, provided that the with respect to compensatory costs, I don't bother. Now, in this Banarsi Das and other series of judgments, what the Supreme Court has said is, taking the benefit under Rule 33, which empowers a court to pass all kinds of orders which in its opinion the trial court should have done it, although a particular person has not preferred an appeal, the respondent cannot get over the provisions of Order 41 Rule 22, where it was absolutely necessary for him to file a cross objection to attack a decree. He can't say under Rule 33 that decree needs to be set aside. Supreme Court has made it clear. Rule 22 and Rule 33, they operate in different spheres, different fields. Taking advantage of the benefit given the powers of the appellate court under Rule 33, the respondent cannot take refuge to it and ignore Rule 22 without preferring a cross objection. When this Rule 33 applies, in fact, there is an illustration here, and I have 2 more illustrations of my own. With that, the legal position will be clear. There is an illustration to Rule 33 given in the statute itself. A claims a sum of money as due to him from X or Y, and in a suit against both, obtains a decree against X. X appeals and A and Y are respondents. The appellate court decides in favor of X. It has power to pass a decree against Y. Now, and in a suit against obtains a decree against X, X appeals. So the appellate court can pass a decree against it. Now let us take one or two examples. Let us take a case of joint borrowers. As per section 43 of the Indian Contract Act, the liability of the joint promisors or joint borrowers is joint and several. Indian law is all joint liabilities are joint and several. Merely because there is a joint liability or there is a joint promise or a joint contract, if one of those joint promisors acknowledges the debt under section 18 of the Limitation Act or makes payment under section 19 for extension of limitation, that will not save limitation as against the other. That is very clear from a reading of section 20 of the Limitation Act. Now, when it comes to a surety, liability of the surety is coextensive with that of the principal debtor and all that fine. But with regard to limitation, there are certain other issues. Acknowledgement of debt is only by the principal debtor. That will not save limitation against the surety. These are number of situations. Now, ultimately, there is a decree against both of them. Only one of them appeals. Let us take a money decree against two persons, either as principal debtor or surety or joint promisors. There is a decree against both of them. Only one of them challenges the decree. Only one of them challenges the decree. The appellate court finds that there is no limitation at all as against either of them. The appellate court is bound to allow the appeal and dismiss the suit. Right. Here, there cannot be two conflicting decrees. A decree against the second defendant who did not prefer appeal, a dismissal against the first defendant, that cannot be two conflicting decrees. So, Order 41 Rule 33 contemplates a situation where relief can be given against persons who are not appealing also. I will give two illustrations and make the position a little more clear. Of course, these are not statutory illustrations. I have drawn it from my experience. Let us take a suit, a simple suit for partition. I am not referring to section 6 of the Hindu Succession Act, amended, unamended, nothing. A simple case of class 1 year succeeding to the estate of a deceased male who dies intestate. A files a suit against her brothers D1 and D2 for partition on the ground that she is also a class 1 heir. So A is the sister of defendants 1 and 2. So she files a suit for partition on the ground that she is also a class 1 heir. The brothers defendants 1 and 2, they admit, well, the property definitely belonged to our father. He died. They also admit that this A is their sister, no dispute. But what they say is that they have acquired the property under a will executed by their father. So the father did not die intestate for section 8 of the Hindu Succession Act to come into force, to come into play. He left behind a will. It's a case of testamentary succession. Plaintiff is not given any share therein, not given anything thereunder. We have become the absolute owners by virtue of the will. So defendants 1 and 2, the brothers, set up a will. The trial court does not accept the will and decrees the suit. So the trial court does not accept the will and decrees the suit. Only one brother, the first defendant, files an appeal. The appellate court upholds the will. Please understand this. Here, Even though the other brother, the second defendant, has not preferred an appeal, the appellate court will have to set aside the decree against the second defendant also, because there cannot be two conflicting decrees. Another illustration. A files a suit for partition against his brothers D1 and D2 on the ground that the suit properties are joint family properties. First is a case where he says they were all self-acquisitions. She succeeded to her father as a class 1 year. Here is a case where a suit is filed by the plaintiff against his brothers on the ground that the suit properties are joint family properties. The first defendant says that some of the properties are self-acquisitions. The second defendant also says that something else is a self-acquisition. That is the stand. The trial court does not accept their contentions. The trial court says that they are all joint family properties. It does not accept the contention of the defendants that any one of them is their self-acquisition and therefore decrees the suit. Only the first defendant appeals. This is not a case where relief can be given to the second defendant under 41 Rule 33, because his contention that some items are his self-acquisition has not been accepted. Here, he can't say, well, though I have not preferred an appeal, in the appeal preferred by the first defendant, I must also be given the benefit under Rule 33. So if he wants to show that these items are his properties, he has to prefer an appeal against that. So this is the position that is emanating from these decisions and other things. Well, from my end, I have said whatever I could have done. Now, a request to the judicial officers once again to strictly comply with the provisions of Rule 23 and Rule 23A while remanding the matter. Their judgment should be very clear, whether it is under Rule 23 or Rule 23A. They are remanding the matter. They can't remand the matter and application is allowed under Rule 27. They would take the path of recording evidence by themselves without directing the trial court to do it. Under Rule 24, when evidence is insufficient, though there are no issues, they will resettle the issues and give a finding. Under Rule 25, there is no evidence, no issue. The option of the trial court certainly is not to remand the matter, frame that additional issue, direct the trial court to give a finding on that issue, record evidence, send it to the appellate court. Till then, the appellate court has to keep the record pending and then dispose of the appeal. Under Rule 27, no question of remanding the matter. Well, stay, I have told you. When the suit is dismissed, there is nothing to be stayed. There is no question of disposal of an appeal on merit when the appellant does not turn up. If you want to adjourn the matter, you can adjourn or dismiss the appeal for non-prosecution. Criminal appeal reverses the situation. Even the respondent in an appeal also can be placed ex parte. Just as we set aside an ex parte decree under Order 9 Rule 30, here under Order 41 Rule 21, the appellate court passes the judgment ex parte, it is open to the respondent. So readmission of appeal under 41 Rule 19 is also provided. Well, this is what I had got to say. Any questions? Welcome. First of all, excuse me, I had to raise a tone and bit this time, unlike on other occasions. So because I get agitated when I speak about Rule 23, 23A and 27.
In the morning itself, I was watching on YouTube and the power of expression was being expressed by Justice Muralidhar. Said that how the evidence is very relevant. He said, I don't know how much Hindi you would understand. He said the relevance of translation and the relevance of expressions while doing it. And he said that you should always record the evidence by some digital means, audio or a video.
Yes.
He says that in Hindi you ask, kya aapne mara? And he asks, maine, expression is maine mara, with an expression, with an exclamation mark. But in the once it is typed, it is written as I killed him. So he says the expression is very important. That the expression should also come in the evidence. So there are two questions, but they're quite long. So I think you will have to read it and explain it. It's in the chat box.
It is settled law that a stranger to the suit can file an appeal if he can satisfy if he is the third person. This generally happens in Andhra to grab the assigned lands. Alias indicate in collision with revenue official a decree without making the real assignee as the party and disposes them with local police. Though there are many remedies, which remedy do you think is the most effective? Well, certainly case law is to the effect that even though a person was not a party to the suit, if he is really aggrieved by the judgment of the trial court, he can seek leave of the appellate court to file an appeal. Well, clear, but the question is this. If he really has no right at all, if he is really not aggrieved, as he said, land mafia and other things, there is no question of he being given leave to prefer an appeal. The second question, I also suggest to please make a video on the best practices for good pleadings, as pleadings are the foundation of the case. I have spoken on this platform about pleadings. If it's necessary again on some other occasion.
So otherwise, sir, he will make me a request on the WhatsApp.
Not at all in the month of June. Then kindly clarify if there is any difference between cross objection and cross appeal. Yes, cross appeal is an independent appeal by the respondent. Cross objection is a kind of an appeal preferred in the appeal filed by the plaintiff. And here, is there any provision for cross appeal? Is a word which we are using it. CPC doesn't make use of that expression at all. So cross appeal is an independent appeal which can be filed by the respondent if there is a finding, if there is a decree against him. Now, in some courts, the procedure appears to be to register the cross objections by giving a separate number. In some courts, they are taken along with the main matter. So there is no specific provision for cross appeal. Cross appeal is an independent appeal by the other side, by the defendant or appellant or by the plaintiff, whoever he is.
So then the period of limitation, can you explain that also? Because
under 41 Rule 22 itself, it is stated, cross objection has to be filed within 30 days from the date on which the respondent receives notice of the appeal, or within such extended time as the appellate court may do it. Normally, the appellate courts are liberal in giving time because when there is a cross objection, it will be easy for them also to do it. And one more thing, just as in the case of counterclaim, if there is a counterclaim, the main suit is dismissed or withdrawn, the counterclaim can continue. Here also the cross objection can continue even if for some reason the main appeal is dismissed. I personally feel if there is a cross objection, even if there is some marginal, even if there is some long delay, better the delay is liberal. I am not interfering in the judicial thinking of the officers, but if you take it, it will be easy for you to dispose of the matter. Otherwise, you will find at the end of the day, conflicting the decisions likely to be handed over from your judgment.
Our two questions.
The last thing is only thank giving, which the participant has chosen to do on behalf of Mr. Vikas.
And two questions I have received on the WhatsApp.
Yes, please.
One, that one moves an application under Order 41, Rule 27, and that application is not decided. What is the fate of that?
Well, in the appellate court, he can, in the second appellate, he can urge it. It should have been taken up, that's all. Here again, whether it could be a substantial question of law, whether even if that application had been considered, ultimate decision would have made some decision, would have made a difference. Maybe those are the questions. Well, my own knowledge of that substantial question of law under 100 CPC is very limited. As I said, I had no occasion to practice in the High Court, nor working the registry, nor a judge. Well, I have not applied my mind to the details in that regard. Maybe from my experience, I should be able to tell, well, if that application is not decided at all, or not considered at all, maybe it could be urged. Well, the second appellate court will have to examine what difference it would have made So the case of the appellant is that application had been considered. That appears to be.
And second question is Order 41 Rule 22 in a cross objection.
Yes.
So, if in that case only delay notice only when the delay has been issued. So your limitation will only start when the delay is controlled. Then you move an application under Order 41 Rule 27, or you can file it prior to that.
The cross objection is only after cross objection is taken on record by condoning the delay. Then only the question of application under Rule 27 would arise. If the appellate court thinks there is absolutely no ground for condoning the delay in preferring cross objection, no question of.
No, sir. The question was the other way around. Appeal has been filed, but only notice has been issued in the delay, and not in the main appeal.
I mean appeal. 41 Rule.
Order 41 Rule 22 will only come.
Rule 27 being considered arises only after the appeal is.
No, Order 41 Rule 27 is not the question. Here is a case where only ordinarily appeal has been filed. Let's assume a first appeal, but notice has only been issued for delay.
Yes.
So Order 41 Rule 22 will only come into being once the delay is controlled. Then only you can file an application, or you can file prior to that also.
See, now the question of cross objection in an appeal would arise only when the appeal is in order. Now notice is issued to him only under party on the application for condonation of delay.
Section 5.
Says itself he also wants to chooses to prefer a cross objection. Maybe it can be kept in the file. If the delay in filing the appeal is condoned, well, that could also be taken up. That appears to be the situation.
And the last question is, you move an application under Order 41 Rule 27, placing on record certain documents. But the other side knows that that application answer would be difficult. So they say that they don't want to file the reply. What is the effect thereof?
If they don't, whether they file the reply or do not file the reply, it is for the appellate court to consider whether a case is made under Rule A or AA or B.
A and A of?
AA or B of Order 41 Rule 27. Okay. Rule 27A, failure of the appellate court, failure of the trial court in admitting evidence it should have admitted. AA, inability of the party to place evidence despite exercise of due diligence. Rule B, requirement of the appellate court. If it thinks well, it would certainly clinch the issue. See, well, let us take a case where a gift or will, the execution of which is in, of course, will disputed or not disputed, one attesting witness has to be examined. Well, the attesting witness was abroad. He was not able to come to the court, bedridden or something. For that reason, the attesting witness could not be examined at all. Despite exercise of due diligence, the appellant tried to get him summoned to the court. Number of times, court also felt sufficient opportunities had been given. The matter was getting old. So without examining the attesting witness, the document has not been proved. Well, the appellate court may think, well, it's a case of Rule AA, despite exercise of due diligence. So that Rule A or AA or B is not confined only to documentary evidence. It can be given even for oral evidence. But though normally it is document, because when once the documents are allowed to be brought on record, naturally somebody will enter the witness box and speak about it. But
no, in Order 41 Rule 27 only the application would be filed. I'm saying on that position. And he doesn't file the reply. What is his fate on that?
He doesn't file it at all.
He says, I will not file the reply to Order 41 Rule 27.
That's what I am telling. Whether he files the reply or not to the application under Rule 27, the appellate court has to see whether the person who has filed the application has made out a case for receiving additional evidence.
Thank you, sir. And we are quite sure that during the June, you will be doing the legal empowerment of PNSS, and we will look forward for those sessions in the month of. We will have training sessions from you once you're free from that. Thank you, and thank you to Kaushik again once again.
Right.
Thank you.
Meet you only after June.
They say May is near, the June is not far off.
Yes.